Hi, good afternoon, and welcome to our seminar on raising money in the capital markets. My name is Mara Smith. I'm a lawyer in the corporate finance branch of the OSC. With me here today are Melanie Skalski and Amanda Ramkasoon, also lawyers in the corporate finance branch. Also here today is Elizabeth Top, a lawyer in the compliance and registrant regulation branch. We just wanted to note at this time three things. The first is that we are happy to take questions at the end of the presentation. The second is that you will receive an evaluation form at the end of the seminar. We're trying a new format this year, so we'd like to get your feedback. And the third thing is that certificates for the seminar will be sent after the presentation, and they will be based on your attendance for the full session. So I'd like to emphasize that the views expressed today reflect our staff views and not the views of the Commission. This presentation is being provided for information purposes only, and it does not represent legal or accounting advice. This is an overview of the main topics we'll be discussing in our presentation today. After a short introduction to the SME Institute, we will provide an overview of the regulatory landscape in Canada. Our main focus, though, will be on how to offer securities on either a private or public basis as a means of raising capital. We first want to provide you with some background on this initiative, so what we call the SME Institute, which is the introduction of a series of educational seminars geared to small businesses. Our main purpose is to help smaller businesses navigate the regulatory system. We want to demystify the regulatory process for small businesses and explain the legal and accounting requirements associated with securities regulation for those of our stakeholders that are not experts in this area. Ultimately, we hope that this will reduce the compliance costs for SMEs and open up channels of communication between the OSC and small businesses. This seminar is not aimed at those who currently practice securities law or who otherwise have knowledge of securities regulation, but rather is an introduction to some of the key concepts around issuing securities in the capital markets. Before we delve into the details of raising capital, we wanted to explain how the regulatory landscape is structured in Canada. I will explain a bit about the different securities regulators, as well as the workings of the OSC corporate finance branch in particular. Liz will then discuss the role of the compliance and registrant regulation branch. Many of you already know that securities law is a provincial matter in Canada. So each province and territory has its own securities regulator, usually a securities commission. Each province or territory also has its own Securities Act and related rules that govern the securities industry. As a group, the provincial and territorial securities regulators are all members of the Canadian Securities Administrators, which is a national body that helps to coordinate the work of the different regulators as much as possible. In addition to each provincial Securities Act, there are a number of other sources for securities law in Canada. Generally speaking, the provincial and territorial securities commissions have the authority to draft rules and policies on different areas of securities law. As much as possible, the provincial and territorial regulators work together on crafting these rules and policies. Much of the requirements relating to securities law can be found in national instruments. These are national rules that are adopted across the country that have the force of law. In some cases, there are also multilateral instruments which are adopted by some but not all jurisdictions. Like national instruments, they have the force of law in the jurisdictions where they have been adopted. We also have companion policies which provide guidance on how the national instrument should be interpreted, but these do not have the force of law. So I'll talk about what the OSC Corporate Finance Branch does. In Ontario, we have different branches that each deal with certain areas of capital markets regulation. The Corporate Finance Branch is the branch that administers the rules applicable to public companies and their insiders. We're responsible for administering the rules applicable to what is called a reporting issuer and their insiders, and monitoring their compliance with those rules. A reporting issuer is defined in our legislation, but to put it simply for the purposes of this presentation, it includes a public company. Insiders are also defined in the Act, but generally speaking includes a company's officers and directors, and I'll refer to this a bit more in detail later on. Securities law has requirements for when and how information must be disclosed by public companies. This ongoing disclosure, or what is sometimes called continuous disclosure, is to help provide investors with timely and accurate information to make informed investment decisions. Staff in the CF branch review this disclosure to monitor compliance with the requirements. We also review prospectuses for public offerings of securities, including initial public offerings. And we consider applications by issuers for relief from any requirements of the Securities Act or related rules. We are also responsible for overseeing how companies raise money in the exempt market, where securities are offered without a prospectus. I'll turn it over to Liz, and she'll tell you about the Compliance and Registrant Regulation branch.
Thanks, Mara. The Compliance and Registrant Regulation branch is responsible for regulating firms and individuals who are in the business of advising or trading in securities and firms that manage investment funds in Ontario. We refer to these people and firms as registrants. Securities legislation and related rules set out registrant obligations, and we monitor compliance with those obligations. The Compliance branch reviews applications for registration. Staff also engage in on-site compliance reviews of registrants. These reviews might be a comprehensive review of a registrant, or they could be focused on one particular issue. Another aspect of the branch's work is to review applications for an exemption from registration requirements.
Thanks, Liz. So the focus of today's presentation is on raising capital, or offerings of securities in the capital markets. Firstly, we will briefly review some of the key concepts in securities law that form the building blocks for the law and are necessary to understand what we'll be discussing today. One of the fundamental requirements in the Securities Act is that if you are selling securities to an investor in a distribution of those securities, then you must provide the purchaser with a prospectus that has been filed with and receipted by the securities regulators. You must do this unless an exemption from providing a prospectus is available. This core requirement is found in Section 53 of the Act, known as the Prospectus Requirement. Exemptions from the prospectus requirement can be found in both the Securities Act and National Instrument 45-106 and other rules. The purpose of requiring a prospectus is that this document contains full, true, and plain disclosure of all material facts about the issuer and the offering, and it's intended to help investors make an informed investment decision about the securities being offered. So I've already mentioned one technical term, which is distribution, but here are some others on this slide that we will briefly touch on and how they relate to issuing securities. So we'll look at what is a security, what is a trade of a security, when does a trade in a security amount to a distribution of those securities and thus requiring a prospectus. We'll look at the requirement to be registered to sell securities and the legal concept of a reporting issuer, aka a public company. All of these terms that I've mentioned are defined and can be found in subsection 1, sub 1 of the Act. The requirements to be registered are found at section 25 of the Act. The definition of security in the Act is very broad, and it covers all of these things and more. Common and preferred shares, bonds, debentures, notes, and other evidences of indebtedness, rights to acquire shares, subscription receipts, warrants, and options, plus any instrument that amounts to an investment contract. The definition of security is purposely broad and provides flexibility to capture other terms or products that in substance are similar. The intent is to ensure that the requirements of the Act apply when appropriate in order to protect purchasers. So what is a trade? The requirement to provide a prospectus applies where there is a trade of securities that amounts to a distribution. A trade is defined in the Act as any sale or disposition of securities for valuable consideration, such as cash. It also includes the receipt by a registrant, such as a broker of an order to buy or sell a security. It goes beyond these specific activities, though, and captures any act, advertisement, solicitation, conduct, or negotiation directly or indirectly in furtherance of any of the activities specified. This restricts the activities done before a sale is made, such as soliciting purchasers to buy the securities, and it's meant to limit the information that is provided to purchasers and potential purchasers to what is found in a prospectus document. What is a distribution? Only certain trades amount to a distribution of securities, so requiring that a prospectus be prepared. A distribution is a trade in securities that have not been previously issued, a trade in previously issued securities by a control person, someone holding a significant block of securities, or a trade in securities by investors who acquired the securities under certain prospectus exemptions. If there is a distribution of securities, the issuer must prepare a prospectus unless an exemption from the requirement to prepare a prospectus is available. An exemption can be available in the rule or in the Act, or it can be applied for and granted on a discretionary basis by the Commission. We'll discuss that in greater detail in just a moment. Generally speaking, where securities were issued under an exemption in the first place, the resale of those securities by the first purchasers is deemed to be a distribution, unless certain resale rules are complied with. This is referred to as the closed system. Securities sold without a prospectus cannot be resold until a prospectus is prepared or otherwise sufficient information is available to enable an investor to make an investment decision. This could either be by providing a prospectus or through continuous disclosure. We'll discuss this more in detail. I'll now turn it back to Liz, and she'll discuss the registration requirement.
So in addition to the prospectus requirement, another key requirement in the Act is that a person or company shall not engage in the business of trading or advising in securities unless they are registered to do so. And this requirement can be found in Section 25 of the Act. More detailed regulation of registrants can also be found in National Instrument 31-103. What it means to be in the business can be broad. In certain cases, an issuer that distributes its own securities may have to register as a dealer. This determination is fact-specific and depends on the types of activities that an issuer is engaged in. These are some of the factors that might indicate an issuer is acting as a registrant. The issuer frequently trades in securities or employs people to act in the capacity of a registrant, or the issuer actively solicits investors. There is guidance in the companion policy to National Instrument 31-103 stating that in general, securities issuers with an active non-securities business do not have to register if they do not hold themselves out as being in the business of trading in securities, the issuer trades securities infrequently, people at the issuer are not compensated for trading, and the issuer does not produce a profit from trading in securities.
Thanks, Liz. So after considering all of the terms that we've gone over, we can go back to what the original framework of securities regulation requires. You cannot distribute securities without providing purchasers with a prospectus. That prospectus is filed with and receipted by the regulators. When a company does file a prospectus with us and it is receipted, it results in the company becoming a reporting issuer, or what is commonly thought of as a public company. There are exemptions from the requirement to provide a prospectus. Issues of securities under an exemption are often referred to as being made in the exempt market. For exempt distributions, sales of securities can only be made to certain investors or under certain circumstances, and it depends on the exemption being relied on as to who those investors can be. Prospectus exemptions are available to both reporting issuers, so public companies, and private companies. Anyone in the business of trading in securities is required to register as a dealer. I'll now turn it over to Melanie to discuss how to raise capital without a prospectus.
Great, thanks, Mara. So we'll now consider in more detail how to raise capital by selling securities without a prospectus in what is referred to as the exempt market. Distributions in the exempt market are often also commonly referred to as private placements. Slide 22 provides an overview of what we will discuss in this section. The main exemptions from the prospectus requirement are found in National Instrument 45-106 and the Ontario Securities Act, and in the case of the existing security holder exemption, OSC Rule 45-501. In each case, the requirements of the particular exemption must be met in order to sell securities without a prospectus. In many cases, this means that no, or only limited, information needs to be provided to purchasers. So why do issuers want to use prospectus exemptions? These offerings are generally less expensive and often faster to execute than prospectus offerings. Preparing a prospectus requires the involvement of lawyers, auditors, and, in many cases, underwriters, which can result in the issuer incurring fees. The stage of the company is also relevant. As Mara mentioned a moment ago, when an issuer files a prospectus, it becomes a reporting issuer, and as a result is subject to ongoing reporting requirements. Some private companies may not be at a stage yet where it makes sense to become a public company, with the regulatory requirements that go with that. I'll just note that the exempt market is very significant in Ontario. We get some information on what is being distributed in reliance on prospectus exemptions because for some exemptions, issuers have to file a report with us after the distribution. The last time we published annual data on exempt market activity was in 2014. At that time, we found that non-investment fund issuers raised approximately $41 billion in Ontario through exempt distributions reported to the Ontario Securities Commission. This capital was raised by a diverse range of issuers using a variety of instruments, which included debt, equity, asset-backed securities, and derivatives. The most widely used exemption was the Accredited Investor Exemption, which we will discuss shortly. Investment funds also raise significant capital in the exempt market. These are pooled funds or hedge funds that are outside of the regulatory regime for mutual funds. So it is important to note that just because it's referred to as the exempt market, this does not mean that it is unregulated. For each prospectus exemption, there are specific requirements that must be followed in order to rely on the exemption in order to distribute securities. As I've already noted, in some cases, we get reports filed within 10 days of an exempt distribution. This gives us important information about the distribution, and Amanda will speak to this in greater detail shortly. And I'd also like to note that just because there is a prospectus exemption that an issuer can rely upon, this does not necessarily mean that there is also a registration exemption. Registrants have certain obligations and responsibilities to their clients, such as the obligation to know your client and conduct a suitability assessment. This means a registrant must understand who the client is, what their needs are, and whether a particular investment is suitable for them. And these requirements still apply in the exempt market. We will walk through the key capital raising exemptions that are used in Ontario today. But just to note before we do that, in the case of each exemption, there is a reason or rationale for why the exemption makes sense, so why full prospectus disclosure is not required. And the goal here is really to balance the objectives that are set out in the Securities Act, namely to permit efficient capital raising and to maintain an appropriate level of investor protection. Slide 26 lists some of the rationales underlying our prospectus exemptions. First, certain exemptions focus on the nature of the investor. For example, a large institution or a person who is considered to be financially sophisticated and able to protect themselves in a transaction, or the fact that an individual has a certain level of income or wealth and thus may be more able to withstand financial loss. Other exemptions are based on the nature of the security, which may make it less risky. An example of this would be certain kinds of government debt. In some cases, there may be an alignment of interests that warrants removing the prospectus requirement. For example, between an employer and employees, or alternative disclosure is provided so that the additional disclosure provided by a prospectus is not necessary. Finally, if an offering is regulated by another regime, then the securities law requirements may not be necessary. We recently conducted a review of the exempt market. This involved several publications upon which we received extensive feedback, as well as numerous public and targeted stakeholder consultations. Our review resulted in amendments to 3 existing prospectus exemptions, as well as the introduction of 4 new prospectus exemptions in Ontario. Our review also highlighted the importance of exempt market reporting, as well as compliance and oversight of exempt market activity. We will also discuss our initiatives in that regard today. Slide 28 lists the most commonly used prospectus exemptions currently available in Ontario. The first exemption we will discuss is the Private Issuer Exemption. This exemption allows non-reporting issuers to distribute securities to 50 people, excluding current and former employees of the issuer or its affiliates, who fall within certain categories. There are transfer restrictions on securities distributed under this exemption, which are intended to allow the issuer to control or be aware of changes in the number of its security holders. A purchaser of securities under the Private Issuer Exemption must fall into one of the categories listed on slide 30. These types of investors are generally thought to have a relationship with the issuer that allows them to mitigate the risks of the investment to some degree, either because of the closeness of the relationship, such as a close personal friend or a family member, or because the investor will have access to information about the issuer and can get the information they need to make an investment decision. Next, we will look at the family, friends, and business associates exemption. This exemption allows both reporting and non-reporting issuers, other than investment funds, to raise money from investors who either are principals of the issuer or have a certain relationship with principals of the issuer, such as immediate family members, close personal friends, or close business associates. The exemption does not require any specific disclosure to be provided to purchasers. However, in some jurisdictions, including Ontario, investors must sign a risk acknowledgement form. The risk acknowledgement form requires that both the investor and the person with whom they have the key relationship indicate what that relationship is and sign the form. The companion policy to National Instrument 45106 provides guidance on the meaning of the terms close personal friend and close business associate. Among other things, it addresses the fact that just because someone is a friend or has a connection on a social media platform, this does not make them a close personal friend or a close business associate. The companion policy also indicates that in Ontario, we would consider the use of registrants or advertising to locate or attract purchasers to really be inconsistent with the exemption, since you shouldn't have to hire someone or advertise to find your friends and family. The guidance also states that the payment of fees or commissions to any person to identify or find family members or friends would, in our view, also really be inconsistent with the use of the exemption. However, fees paid in certain circumstances may be acceptable, such as fees paid to prepare any documentation or for activities related to the closing of a distribution under the exemption. So the next exemption we'd like to discuss with you today is the Accredited Investor Exemption. And before getting into the specific features of the exemption, I would just like to note again the significance of this exemption to our capital markets. It is the most used prospectus exemption based on information we have gathered from reports filed with us. Under this exemption, any issuer can sell securities to an investor that qualifies as an accredited investor. Slide 34 sets out some of the categories of individual accredited investors. In general terms, individuals can qualify as accredited investors if they meet one of the following tests. First, the individual has net income of at least $200,000 in each of the past 2 years, or together with a spouse, $300,000. Second, the individual has, either alone or with a spouse, financial assets of at least $1 million net of related liabilities. And I just note that this excludes real estate, such as your house, with the idea here being that financial assets are generally liquid or easy to liquidate. And finally, the individual, alone or with a spouse, has net assets of at least $5 million, and this can include real estate. Listed on slide 35 are some of the non-individual entities that qualify as accredited investors. And taking a look at this list, you can see that these generally are large entities, and they are considered to have the necessary expertise to take care of their own interests. It's interesting to note that not many people actually qualify as accredited investors. So a few years ago, back in 2012, as part of our exempt market review, we looked at some data from Statistics Canada on Canadians' income. And based on that data, our economists estimated that at that time, people with incomes at or above $200,000 accounted for approximately 1.3% of tax filers in Ontario and 1.1% of tax filers across Canada. And looking at all of the criteria for individuals, so both the income and asset thresholds that I just outlined, our economists estimated that at that time, the total number of individuals qualifying as accredited investors under these tests was less than 4% of the Ontario and Canadian populations. So turning to slide 37, really the main requirement under the exemption, other than the need for purchasers to qualify as an accredited investor, is the requirement for any purchaser that is an individual that qualifies as an accredited investor under the test I outlined to complete a risk acknowledgement form. However, permitted clients are not required to sign the form. And the main purpose of the risk acknowledgement form is to provide, in plain language, a description of some of the key risks associated with making an investment in the exempt market, and also to provide a short, clear description of the categories of individual accredited investor and to require the investor to confirm which category they fall into. The companion policy to National Instrument 45106 provides some guidance on the steps a seller could take to confirm that a purchaser is in fact an accredited investor. And this guidance was recently put into place to address concerns that in some cases, individuals purchasing securities under the exemption had not actually qualified as accredited investors. The guidance emphasizes that the person relying on the exemption is responsible for determining that the conditions of the exemption are met, and also that any registrant acting on behalf of a seller must also comply with all of the registrant obligations under National Instrument 31103, including the requirement to know your product, know your client, and conduct a suitability assessment. And really, the guidance goes beyond just the accredited investor exemption and focuses on the need to verify a purchaser's status more generally for those prospectus exemptions that are based on a purchaser having certain characteristics. So for instance, under the accredited investor exemption, there are the income and asset thresholds. And under the family, friends, and business associates exemption, there are relationships that must exist between the purchaser and the principal of the issuer. And the guidance notes that the seller must obtain information from the purchaser in order to determine whether the purchaser does meet the applicable test. So in particular, it is not enough to simply accept standard representations, for example, in a subscription agreement, or to accept that the purchaser has initialed beside a category of accredited investor in the risk acknowledgement form, unless the seller has taken reasonable steps to verify the representations made by the purchaser. So we'll turn next to the minimum amount investment exemption. While this exemption is used less than the accredited investor exemption, it still is a very significant source of capital raising. And under this exemption, any issuer can sell securities to any non-individual investor, provided that the acquisition cost of the securities is at least $150,000 and is paid in cash at the time of the distribution. Historically, issuers could distribute securities to individuals under this exemption. Restricting the exemption to non-individual investors was one of the outcomes of our exempt market review, and this change was really made as a result of concerns that were identified during the course of that review. So next, we'll discuss two exemptions that allow issuers to sell securities to existing security holders in certain circumstances: the rights offering exemption and the existing security holder exemption. We will turn first to the rights offering exemption, which allows reporting issuers to grant rights to existing security holders to purchase securities of the issuer. Security holders can then exercise their right to acquire securities, do nothing, or trade their rights to someone else. Slide 41 provides an overview of the process that is undertaken under the exemption. So in order to rely on the exemption, an issuer is required to give notice to all security holders that it intends to conduct a rights offering. The notice requires basic disclosure about the offering and also informs security holders of how to access the rights offering circular electronically. This notice is intended to be a relatively brief document. The issuer must then file a rights offering circular, which I will discuss in more detail in a moment. Other requirements are set out in Section 2.1 of National Instrument 45106 and include that the price must always be at a discount for a listed security, that there is a 21-day exercise period, and other mechanics. Slide 42 provides more detail about the rights offering circular. So after mailing the notice that I just referred to security holders, the issuer must post a rights offering circular with further details about the offering on SEDAR. We introduced streamlined disclosure requirements for rights offering circulars and have really tried to focus these requirements on areas where staff have had concerns regarding disclosure in the past. For instance, there are now more detailed requirements for disclosure of the expected use of proceeds. It is important for investors to understand how the proceeds will be used, particularly in light of the fact that a reporting issuer could increase its outstanding securities by up to 100% under the exemption. Another area that staff often raise concerns on or comments on, particularly in the last few years, is around an issuer's financial condition. So the current requirements are intended to provide investors with transparency about an issuer's financial condition so that they can make an informed investment decision. The next exemption we will discuss is the existing security holder exemption. This exemption provides a way for issuers that are publicly listed to raise capital from existing investors in reliance on the issuer's public disclosure record. Given the focus of this exemption on an issuer's existing continuous disclosure record, there is minimal disclosure required of an issuer relying on the exemption. Issuers must issue a news release that describes the proposed distribution and use of proceeds in reasonable detail, and this must be filed on SEDAR. No point of sale disclosure is prescribed. Under the exemption, an issuer can increase its outstanding securities by up to 100%. However, investors are limited to a purchase amount of $15,000 in a 12-month period if suitability advice has not been obtained from a registered investment dealer. If the investor has received suitability advice, there is no limit on the amount that the investor can invest. An offer under the exemption must be made to all security holders, but there is no requirement to allocate the securities on a pro rata basis. Also, the duration of the offer is not prescribed. However, if there is a short offer period, we may have concerns about whether the issuer did in fact make a bona fide offer to all security holders, depending on the facts and circumstances. For example, if an offer period was very short and a small number of security holders took up all of the securities, we may have concerns about whether an offer was really made to all of the security holders. If security holders have an identical opportunity under the exemption, then they are considered to be treated identically. While there is no pro rata requirement, in order to support the fair treatment of all security holders, an issuer should establish, maintain, and apply policies and procedures that provide reasonable assurance that the issuer and, if applicable, any involved registrant, fairly allocate investment opportunities among the issuer's security holders. There is no requirement that an issuer accept all subscriptions from each existing security holder. However, if an issuer were to reject a subscription that was in all respects a valid subscription, it could call into question whether the offering was made available to all security holders of the issuer. While an issuer might not want to accept small subscription amounts because of the administrative burden, for transparency purposes, an issuer should consider clearly disclosing the minimum subscription amount in the offering news release. Lastly, I will note that secondary market civil liability applies to securities that are distributed under this exemption. So now that I've explained the existing security holder exemption, you might be wondering how this is different from a rights offering. Slide 46 summarizes some of the differences between the existing security holder exemption and rights offerings. The first difference relates to investor eligibility. In a rights offering, the rights may be traded on the secondary market. On the other hand, under the existing security holder exemption, only existing security holders may use the exemption. The second difference I want to highlight is around the allocation of securities. In a rights offering, rights are issued to each security holder so they have an equal opportunity to participate in the offering. On the other hand, under the existing security holder exemption, there are no requirements around the allocation of securities available. However, issuers should keep in mind that they need to make a bona fide offer to all security holders of that class of securities. Another difference is the disclosure provided to investors. In a rights offering regime, there is a prescribed form. The existing security holder exemption does not have a prescribed form or any point of sale disclosure. And the fourth difference relates to the offer period. While there is no prescribed offer period under the existing security holder exemption, the rights offering exemption provides for a minimum 2-day exercise period. The last difference I want to highlight relates to resale. Securities distributed under a rights offering are not subject to resale restriction, whereas securities distributed under the existing security holder exemption are subject to resale restrictions which impose a 4-month hold period on securities distributed under the exemption. So although the exemptions are similar, we do believe that they do have some differences and provide reporting issuers with additional flexibility in determining financing arrangements. I'll just briefly touch on the securities for debt exemption. This exemption is perhaps not technically a capital raising exemption. It's included in the section of National Instrument 45106 under transaction exemptions. But this is an exemption that may be useful for smaller businesses. Under the exemption, a reporting issuer can distribute securities to a creditor to settle a bona fide debt of the issuer. The next exemption we will discuss today is the Offering Memorandum Exemption. This exemption allows for the distribution of securities to investors without a prospectus, provided that another type of disclosure document, an offering memorandum, is provided instead. The form of offering memorandum is set out in National Instrument 45106, and the disclosure is somewhat less than that required by a prospectus. There are some different models of this exemption currently in place across Canada. Today we will be focusing on the requirements of the exemption that apply in Ontario. The Offering Memorandum Exemption is available to both reporting and non-reporting issuers, and in certain jurisdictions, including Ontario, it is not available to investment funds. There are no other restrictions on the type of issuer that can rely on the exemption. However, there are restrictions on the type of securities that can be distributed under the exemption. Issuers cannot rely on it to distribute specified derivatives or structured finance products. There are no limits on the amount an issuer can raise under the exemption or on the length of time an offering can remain open. There's also no prohibition on involvement in an offering of a registrant that is related to the issuer distributing securities. However, we do have guidance in the companion policy to National Instrument 45106 indicating that where a registrant is providing suitability advice to a purchaser in respect of an offering by a related or connected issuer, we do expect the registrant to be aware of the conflicts that can arise in these circumstances and to take appropriate steps to respond to those conflicts in order to ensure that it is meeting its regulatory obligations. For instance, the guidance notes that registrants should be able to demonstrate that they are addressing the conflicts by avoiding or managing and disclosing them appropriately. Any marketing materials used in connection with the distribution under this exemption must be incorporated by reference into the offering memorandum. This means that marketing materials are subject to the same standard of liability as the offering memorandum itself in the event of a misrepresentation. We also have guidance in the companion policy to National Instrument 45106 around the use of marketing materials under the exemption and our expectations of issuers and registrants in this regard. At a high level, the guidance indicates that an issuer or registrant that uses marketing materials under the exemption should review the materials to confirm that they are consistent with the offering memorandum and are fair, balanced, and not misleading, and also to determine whether any claims set out in the marketing materials adequately refer to supporting information. The guidance also includes a discussion on marketing materials prepared by a third party and notes, among other things, that an issuer or registrant should not rely on marketing materials prepared by a third party without independently reviewing the materials prior to use. Relevant to this exemption is the concept of an eligible investor, which requires investors to meet certain income or asset thresholds. Generally, in order to be an eligible investor, a purchaser must have net assets, alone or together with a spouse, in the case of an individual, that exceed $400,000, or net income that exceeded $75,000 alone, or $125,000 with a spouse, in each of the 2 most recent calendar years, and must also have a reasonable expectation that this income threshold will be met in the current year. The concept of an eligible investor is really relevant for the purpose of determining how much an investor can purchase under the Offering Memorandum Exemption. In Ontario and certain other jurisdictions, there are limits on the amount that certain individual investors can invest. In Ontario, we have a tiered approach to investment limits based on investor status. Accredited investors and investors who would qualify to purchase securities under the Family, Friends, and Business Associates Exemption are not subject to any investment limits. Similarly, non-individual investors are not subject to any investment limits. Eligible investors can invest up to $30,000 under the exemption in a 12-month period. However, this $30,000 limit may be exceeded by an eligible investor who receives advice from a portfolio manager, investment dealer, or exempt market dealer that exceeding the investment limit of $30,000 and the investment itself is suitable for the investor. In this case, the investment limit for all securities acquired by the purchaser under the Offering Memorandum Exemption in the preceding 12 months is $100,000. Non-eligible investors can invest up to $10,000 in a 12-month period. So I just note that the investment limits apply over a 12-month period, not a calendar year. This means that each time an investor wants to purchase securities under the Offering Memorandum Exemption, it is necessary to look back to the 12 months preceding that particular investment. The next slide provides an overview of some of the other key features of the exemption. As another investor protection measure, all investors must sign a risk acknowledgement form. Individual investors must also complete 2 schedules to the risk acknowledgement form. These schedules require investors to indicate how they qualify to invest. So for instance, whether they are eligible investors or non-eligible investors, and to confirm that they are investing within any applicable investment limits. The schedules also require details to be provided with respect to any registrant that has provided advice to the investor. The companion policy to National Instrument 45106 provides guidance indicating that notwithstanding the representations made by a purchaser in these schedules to the risk acknowledgement form, we do expect an issuer to be able to explain what steps were taken to verify the representations made by the purchaser. We also recognize that in many circumstances, a registrant may act as agent on behalf of an issuer for this process. In this regard, we refer issuers and registrants to the guidance in Section 1.9 of the Companion Policy to National Instrument 45106 regarding steps that can be taken to verify the representations of a purchaser. In terms of point of sale disclosure, investors must be provided with an offering memorandum in the prescribed form, and the same form of offering memorandum is currently used in every jurisdiction of Canada. Non-reporting issuers that rely on the exemption are required to provide investors with some disclosure on an ongoing basis, including audited annual financial statements, an annual notice describing how the issuer has used the money raised under the exemption, and notice upon the occurrence of certain key events, including a discontinuation of the issuer's business, a change in the issuer's industry, or a change in control of the issuer. So one other feature of the Offering Memorandum Exemption that I'd like to note before moving on is that investors under the exemption have a 2 business day right of withdrawal with respect to securities that they've purchased. The last exemption that we will discuss is the crowdfunding exemption set out in Multilateral Instrument 45108. Multilateral Instrument 45108 was initially available in Ontario, Manitoba, Quebec, New Brunswick, Saskatchewan, and Nova Scotia, and on October 31st, 2016, the Alberta Securities Commission announced that it had also adopted Multilateral Instrument 45108. So before getting into the features of the exemption, I'll start by talking briefly about what we mean by the term crowdfunding. Crowdfunding is a method of funding a project or venture for amounts of money raised from members of the public over the internet via an online portal. There are many different forms of crowdfunding that currently exist, and we have listed some of the different types on slide 51. For example, someone may donate to a project or enterprise and receive nothing in return. Alternatively, they could receive some type of a reward or perk, like a t-shirt or a DVD. Some people may fund a business by pre-purchasing the product that the business is trying to create, such as, for instance, a watch. The crowdfunding that we are talking about, however, is the emerging area of raising capital from the public over the internet by issuing securities. So turning now to the key elements of the crowdfunding regime. In terms of issuer qualifications, the crowdfunding exemption is available to both reporting and non-reporting issuers. It is not available to investment funds or blind pools. An issuer seeking to rely on the exemption must be incorporated or organized in Canada and have its head office here. In addition, a majority of the issuer's directors must be resident in Canada. However, the principal operating subsidiary of the issuer, if any, can be incorporated or organized in Canada or the U.S. We think that this could provide greater flexibility for issuers in structuring their affairs. There are some limits on the types of securities that can be offered under the exemption. Multilateral Instrument 45108 sets out a limited list of securities that may be offered that are really intended to be relatively straightforward and easy to understand. There's a cap on how much money an issuer can raise under the exemption. An issuer group, that is the issuer, its affiliates, and any other entity that is engaged in a common enterprise with the issuer or its affiliate, is limited to raising $1.5 million on a rolling 12-month period, ending on the last day of the distribution period. A crowdfunding distribution can only remain open up to 90 days. The idea here is that we do not want the point of sale disclosure to become stale. An issuer may only distribute securities through a single registered funding portal, which I'll discuss in more detail momentarily. A distribution under the crowdfunding exemption cannot close unless sufficient proceeds have been raised in order to accomplish the issuer's business objectives as disclosed in its crowdfunding offering document. So this includes proceeds raised under the distribution and under any concurrent distributions. The issuer can distribute securities under other prospectus exemptions with different price, terms, and conditions. In terms of solicitation and advertising, an issuer cannot advertise a distribution or solicit purchasers. Additionally, the issuer may only advise potential investors that it plans to offer securities under the crowdfunding exemption and direct investors to the funding portal with the offering. For example, a bakery doing a crowdfunding offering could post a notice in its store window, hand out leaflets, or send a tweet to let its customers and others know that it is offering securities under this exemption and on which portal more information about the offering may be found. All other advertising and solicitation by the issuer is prohibited. All offering materials of the issuer must only be made available to investors through a single funding portal. This is intended to make it easy for investors to locate the information and to facilitate the exchange of information and views conducive to eliciting the wisdom of the crowd. A funding portal may only advertise that it is in the business of distributing securities under the crowdfunding prospectus exemption. So for instance, the portal may not advertise, highlight, or showcase a particular issuer or distribution. So for instance, it can't have a featured deal on its website. The crowdfunding regime contains a number of measures intended to make investors aware of the risks that are associated with a crowdfunding investment and to limit their exposure. One of these is investment limits. For non-accredited investors, the limits are $2,500 in a single investment and, in Ontario and Alberta, an annual limit of $10,000 in total during a calendar year. For accredited investors, the limits are $25,000 in a single investment and, in Ontario and Alberta, an annual limit of $50,000 in total during a calendar year. The other jurisdictions do not have annual limits. In addition, in Ontario and Alberta, there are no investment limits for permitted clients. In other jurisdictions, permitted clients have the same limits as accredited investors. In terms of compliance with the investment limits, we do expect a funding portal to take reasonable steps to confirm that each purchaser understands and complies with the applicable investment limits. A funding portal should have appropriate policies and procedures in place to confirm and verify the purchaser's investor status, the applicable investment limits, and whether the purchaser is in fact in compliance with the applicable investment limits. In Ontario and Alberta specifically, these procedures must include obtaining a completed Form 45108F3, which is a confirmation of investment limits, from the purchaser prior to accepting any funds from the purchaser. If a purchaser specifies that it is an accredited investor or a permitted client, the funding portal should obtain further information from that purchaser in order to determine whether the purchaser has the requisite income or assets to meet the terms of the accredited investor or permitted client definition. And then as a next step, when entering the funding portal's online platform, the funding portal must take reasonable steps to confirm that a person or company understands and acknowledges a few things. First, that a distribution posted on the funding portal's online platform has not been reviewed or approved in any way by a Securities Regulatory Authority or regulator. Second, that the distribution is risky and may result in the loss of all or most of an investment. Third, that the person or company may receive limited ongoing information about an issuer or an investment made through the funding portal. And finally, whether they will or will not receive suitability advice depending on the type of dealer that is operating the funding portal. So this could be done, for example, through a pop-up window on the portal. Investors must also sign a risk acknowledgement form requiring them to positively confirm having read and understood the risk warnings and information in the crowdfunding offering document before they can enter into an agreement to purchase securities. Purchasers may withdraw their offer to purchase within 48 hours after the date of the agreement to purchase securities and within 48 hours after the date of any amendments to the crowdfunding offering document. And a little bit more detail in terms of what that crowdfunding offering document entails. The issuer must prepare and provide to potential investors an offering document that describes the issuer and its proposed business. The thinking here was that the offering document will be easier for investors to read and understand than a prospectus. It is designed to provide investors with relevant information they need to know to make an informed investment decision. It is also intended to be more cost-effective and faster for issuers to prepare. Reporting issuers are subject to liability in the event of a misrepresentation in the offering document. Non-reporting issuers are subject to liability in the case of an untrue statement of a material fact in the offering document. An issuer may also make available to investors a term sheet, a video, or other materials that summarize the information contained in the crowdfunding offering document. These materials would be subject to similar liability as the offering document itself. Financial information must also be provided at the point of sale, and whether the financial statements need to be audited or reviewed depends on the amount an issuer has raised under one or more prospectus exemptions since the issuer's formation. In terms of ongoing disclosure, Multilateral Instrument 45108 establishes some limited ongoing disclosure requirements on non-reporting issuers using the crowdfunding exemption. These requirements are similar to those required under the Offering Memorandum Exemption for non-reporting issuers. So, for instance, non-reporting issuers are required to provide to investors and deliver to the Securities Regulatory Authorities annual financial statements, along with disclosure on how they have used the funds raised. Also, in Ontario, New Brunswick, and Nova Scotia, non-reporting issuers are required to provide to investors a notice of specified key events within 10 days of the event occurring. These events are a discontinuation of the issuer's business, a change in the issuer's industry, and a change of control of the issuer. Reporting issuers using the exemption must continue to comply with their ongoing reporting requirements under securities laws. Slide 56 provides an overview of the registration framework for funding portals. So one of the key investor protection measures of Multilateral Instrument 45108 is that crowdfunding distributions can only be made through a registered funding portal. A funding portal may be registered as a restricted dealer, an exempt market dealer, or an investment dealer. A funding portal that is registered as a restricted dealer cannot be registered in any other registration category. For example, a funding portal cannot be registered as both a restricted dealer and an exempt market dealer. In Ontario and Alberta, a funding portal registered as a restricted dealer cannot be affiliated with another registered firm. A restricted dealer funding portal is really intended to be a specialized type of restricted dealer that can only rely on the crowdfunding exemption to facilitate distributions of securities. A restricted dealer funding portal is not permitted to provide recommendations or advice. That means a restricted dealer funding portal cannot tell a purchaser that the securities are a good investment, that the securities meet the purchaser's investment needs or objectives, or that the purchaser should buy the securities. Exempt market dealers and investment dealers are, as I noted, also allowed to use the crowdfunding prospectus exemption. And in addition, exempt market dealers and investment dealers relying on the exemption are also required to comply with all of their obligations as an exempt market dealer or as an investment dealer, in addition to the applicable requirements and restrictions set out in Multilateral 45108, such as the restriction on advertising and solicitation. So in terms of prohibited activities, I'd just like to note that a funding portal is not permitted to participate in a distribution of securities of a related issuer. However, this restriction does not prevent a funding portal from accepting securities of an issuer as payment of portal access fees or other similar fees, provided that the payment by the issuer does not result in the funding portal holding 10% or more of the outstanding voting securities of the issuer. And as referred to earlier, a funding portal cannot advertise or solicit. So this concludes our discussion of the crowdfunding exemption and our broader discussion of the key prospectus exemptions that are used in Ontario today. I'll now turn it over to Amanda, who will go over our exempt market compliance program, how exempt distributions are reported to us, and the resale restrictions that apply to securities distributed under certain exemptions.
Since the introduction of the new capital raising exemptions in Ontario, the OSC has developed a compliance and oversight program to monitor exempt market activity and distributions under the new and existing capital raising exemptions. The Corporate Finance Branch and the Compliance and Registrant Regulation branches have primary responsibility for exempt market compliance. The Compliance and Oversight program has three main elements: assessing compliance, enhancing awareness, and data gathering. In connection with assessing compliance, our intake staff reviews reports of exempt distribution to ensure compliance with the requirements of Form 45-106-F1. Some of the things that we look at in terms of assessing compliance is the appropriate use of exemptions, compliance with investment limits, whether the risk acknowledgement forms are being used correctly, and, of course, whether the offering documents and other disclosure that investors are receiving is appropriate. Staff hopes to create awareness in the exempt market issuer and dealer community of the terms of the exemptions and our monitoring activities by conducting training seminars, such as this one, and also by engaging with exempt market issuers regarding compliance matters. Data gathering is an important part of our exempt market compliance and oversight program. Gathering data on the types of issuers using exemptions, the types of securities being offered, the amounts being raised, and trends in the use of exemptions will assist us in refining the compliance and oversight program and facilitate public reporting of exempt market activity. All of the data gathered on exempt market activity will also assist us in informing future policy work and determining whether the terms of the current exemptions strike the right balance between investor protection and facilitating capital raising. One of the key ways we obtain information about exempt market activity is through a report that is required to be filed with the regulator when certain prospectus exemptions are used. A new report of exempt distribution came into force in all CSA jurisdictions on June 30th, 2016. The new report of exempt distribution is now harmonized across all CSA jurisdictions, and in doing so, reduces the compliance burden for issuers and underwriters. The new report is tailored to the type of issuer, being either an investment fund issuer or a non-investment fund issuer, and requires issuers or underwriters to provide information that was not required in the previous iteration of the report of exempt distribution. As discussed previously, this additional information will enable more effective regulatory oversight of the exempt market and improve analysis for future policy development. Some of the new information requirements include additional details about the issuer, the identities of the directors, executive officers, and promoters, additional details about the securities being distributed and the documents provided in connection with the distribution, and additional details about the compensation paid to dealers, binders, and promoters. An issuer or underwriter must file the report in the jurisdiction where the distribution takes place no later than 10 days after the distribution. Investment funds relying on certain prospectus exemptions have the option of filing Form 45-106-F1 on an annual basis within 30 days of the end of the calendar year. The reports of exempt distribution can be filed by completing an electronic form on the OSC's electronic filing portal. The British Columbia Securities Commission also has a web-based filing system on e-services. In all other CSA jurisdictions, the report is required to be filed on the System for Electronic Document Analysis and Retrieval, or SEDAR for short, which is the CSA filing system for certain documents that are required to be filed with the regulators. Both the BCSC's e-services and the OSC's electronic filing portal generate an electronic copy of the report of exempt distribution that can be used to file on SEDAR in all other jurisdictions. Following the introduction of the new capital raising exemptions in Ontario and the Exempt Market Compliance and Oversight Program, the OSC has launched an Exempt Market resource page on the OSC website. This resource page provides information and helpful links for the exempt market investor, issuer, and dealer community. I will highlight a few. The OSC publishes periodic exempt market data on distributions which occurred in Ontario, including the amounts raised and the number of purchasers. On the resource page, you will also find links to all CSA and OSC exempt market publications, including rule amendments and staff notices. Presentations by staff like this one will also be posted on this page. Lastly, this page contains the relevant links to forms required by issuers to satisfy their filing requirements, including the form of offering memorandum, risk acknowledgement form, and notice of use of proceeds. And once issuers and underwriters are prepared to file their report of exempt distribution and supporting documents, the resource page includes a link to the OSC's electronic filing portal. One last exempt market resource that I want to highlight is CSA Staff Notice 45308, Guidance for Preparing and Filing Reports of Exempt Distribution under National Instrument 45106, Prospectus Exemption. This staff notice was meant to assist issuers, underwriters, and their advisors in preparing and filing reports by providing guidance on how to complete certain aspects of the form. If reports of exempt distribution are incomplete or contain inconsistent information, filers may receive correspondence from staff asking them to amend the form or provide additional information. CSA Staff Notice 45308 includes tips for completing and filing a report, which outlines some tips for completing the key components of the report, and a checklist of information requirements introduced in the 2016 report, which outlines all of the new information requirements for the new report of exempt distribution to assist filers in gathering all of the required information in preparation for filing the report. The staff notice also includes a frequently asked questions portion, which outlines some of the common inquiries that filers may have as they complete the report. Filers are encouraged to review CSA Staff Notice 45308 before submitting their first report of exempt distribution. Once a security has been issued in reliance on a prospectus exemption, that does not mean that the purchaser of the security can freely resell it to someone else. Instead, there is a set of resale rules that apply to subsequent trades. These rules are set out in National Instrument 45102, Resale of Securities. These rules essentially deem the resale of securities acquired under an exemption to be a distribution, which then requires a prospectus to be filed and receipted. However, the rules also provide that resales will not be deemed to be distributions if certain conditions are met. These conditions are set out in either sections 2.5 or 2.6 of National Instrument 45102. The rules might impose a restricted period or a seasoning period on the securities. A restricted period, also known as a hold period, requires that the purchaser hold the securities for 4 months. In addition, the issuer itself must be a reporting issuer or public company and must have been one for the 4 months immediately preceding the trade. If there is a seasoning period requirement, the issuer must be a reporting issuer and have been one for the 4 months preceding the resale trade. The purpose of requiring the issuer to be a reporting issuer is to ensure that when the exempt securities are resold into the open market, there has been a public disclosure record for a certain period of time on which investors can base an investment decision. I will now turn it back to Mara to discuss sales of securities in the public markets.
So now that we've discussed issuing securities without going public, I will discuss common methods to go public. An initial public offering, or an IPO, is the traditional method of going public. The IPO process involves preparation of the prospectus with legal counsel and then clearance with the regulators. The advantage is that you reach more investors. The disadvantage is that there is time and cost associated with preparing the prospectus. There are two other ways to raise capital that I'll discuss. We'll then return to the IPO afterwards. A second way to go public is a reverse takeover. A reverse takeover can be effected through a merger, asset purchase, or share purchase. Ultimately, a private company becomes a subsidiary of the public company, or its assets are vended to the public co. The public company may be a shell company with no active business, and the private company will have an active business. The shareholders of the private company become majority shareholders of the public company. Another form of IPO is to raise capital through a capital pool program. The TSXV allows a capital pool program with no assets other than cash from seed round financing and has no operations to conduct an IPO and become a listed issuer on the TSX Venture Exchange. So now back to the IPO. I'll discuss the process to conduct an IPO, regulatory issues associated with this process, the different requirements for venture issuers, and what we typically see in these reviews. The OSC engages in a comment letter process with the issuer. The issuer files their preliminary prospectus, which we review. We then issue comments to the issuer. There may be several more rounds of comment and reply letters between the OSC and the issuer. Once our comments are all resolved, the issuer is cleared to file the final prospectus. And once the final prospectus is filed, they are issued a receipt. Some of the key regulatory issues relate to the quality of the disclosure in the prospectus, what the size and structure of the offering is, the issuer's financial statements, management discussion and analysis, and escrow. Basically, the prospectus tells the story. The overriding principle is that a prospectus must contain full, true, and plain disclosure of all material facts relating to the securities issued or proposed to be distributed. The prospectus should provide a clear understanding of the company, including its history, performance, and future expectations. It should also explain the nature of the securities being offered. Also, the prospectus should set out the risks associated with the security being offered and the company. The prospectus should be balanced in that it doesn't overemphasize the positive or downplay the negative. If the issuer is using marketing materials, anything that is produced in the marketing materials has to be disclosed in or derived from the prospectus. Material information is information that would impact a reasonable investor's decision on whether or not to buy, sell, or hold the company's securities. The information in one section of the prospectus should always align with information in other sections and be consistent. Finally, where possible, the prospectus should use plain language. A common regulatory issue that I mentioned is whether the company has raised sufficient proceeds to accomplish the purpose for which they are doing the offering, and that it must raise sufficient funds to continue operations. If it cannot, a receipt for the prospectus will be refused and the financing will not proceed. The prospectus must contain clear disclosure on how the issuer intends to use the proceeds raised in the offering, as well as disclosure of the issuer's financial condition, including any liquidity concerns. This disclosure is important to investors because it provides warnings about significant risk that the issuer is facing or may face in the short term. Relevant information in this context may include disclosure on negative cash flow from operating activities, working capital deficiencies, net losses, and significant going concern risks. I'll note that disclosure on its own may not be sufficient to satisfy receipt refusal concerns in certain circumstances. For example, a recommendation of receipt refusal may be appropriate where an issuer lacks sufficient funds to continue operations, or if the proceeds from the prospectus offering will be insufficient to accomplish the purpose of the offering. An issuer's IPO prospectus must include the items on the slide for both the most recent annual period and most recent interim period. As I will discuss a bit later, the requirement for 3 years of audited financial statements has been reduced to 2 years for venture issuers. Financial statements are also required for any significant or probable business acquisition. Again, as I will discuss later, venture issuers are no longer required to include pro forma financial statements in their business acquisition report. One matter to consider is whether in a particular circumstance the business acquired or being acquired would constitute the primary business of the issuer. So this should be checked with us regarding predecessor financial statements. I'll also note that if the issuer is including non-GAAP or non-IFRS measures, they should ensure that they are complying with CSA staff known as 52306 non-GAAP financial measures. Among other things, the non-GAAP measures should be presented with equal or greater prominence as the GAAP measures. Management discussion and analysis must accompany the financial statements, both annual and interim, in an offering document. MD&A tells a story through the eyes of management of how the company performed during the period. MD&A should provide a balanced discussion of the company's financial performance during the period, so this means good news as well as bad news needs to be reported. Financial statements and MD&A must be reviewed, approved by company's audit committee and the board of directors. Here I'll note that a more common concern, given the current market conditions, is deficiency with disclosure regarding liquidity and capital resources. Other areas for improvement are issuers with a working capital deficiency provided very general discussion or no discussion about potential sources of financing and how they plan on continuing operations. Another area for improvement is that issuers did not appropriately disclose the identity of the party involved in the related party transaction. Turning to escrow, which is set out in National Policy 46201. There are 3 purposes of escrow. 1, to tie principals to issuers. 2, to equate risk and reward between founders and the public. And 3, to keep cheap shares off the market. I'll note that there are additional or different escrow terms if the offering is not underwritten, if the issuer is not applying to list on a Canadian exchange, or they are rejected, and there are other exceptional circumstances. Disclosure requirements are streamlined for venture issuers. The nature and purpose of streamlining the requirements for venture issuers was to more sharply focus the disclosure on the needs and expectations of venture issuer investors. This allows management of these issuers to focus on the growth of their business and enhance the governance requirements for venture issuers. Venture issuers have the option to fulfill the interim MD&A requirements by preparing and filing a streamlined disclosure document, referred to as quarterly highlights. This applies in each of the first 3 quarters. This is optional. Venture issuers can alternatively choose to comply with the full interim MD&A requirement. The requirements reduce the instances in which a business acquisition report must be filed. The BAR report, the business acquisition significance threshold for venture issuers has been raised to 100% from 40%, therefore reducing the number of instances where BAR reports are required. BARs filed by venture issuers are no longer required to include pro forma financial statements. This also applies where BAR level disclosure is required. So in information circulars and short form prospectuses, for example. Prospectus disclosure for venture issuers includes a tailored form of executive compensation disclosure, and it reduces the number of years of audited financial statements required for venture issuers becoming reporting issuers. The audit committee requirements for venture issuers require that audit committees must have a majority of independent members. Venture issuers must have an audit committee composed of a minimum of 3 members, the majority of whom cannot be executive officers, employees, or control persons of the issuer or an affiliate of the issuer. This aligns with existing TSX venture requirements. As mentioned, during the IPO process, the OSC and the issuer engage in a comment letter process. Ensuring that you provide a comprehensive response to each question assists in moving things along efficiently. If requested, the issuer should include detailed analyses which reconcile to their financial statements and other filings. When asked questions relating to the financial statements, it is helpful to cite accounting references. We are always available to have a call with an issuer if need be. This can help with clarifying questions or responses and staying on track. So here's our contact information should you wish to have an offline discussion. Thank you for attending our presentation today.